Okay, so today's webinar, we've partnered up with the Flanders-China Chamber of Commerce, and I'm representing the China IP SME Helpdesk. And our webinar today is about key IP considerations for cooperation with Chinese partners. So at any point, people can join. So we'll just get started right now. So I'll just give a brief introduction to the help desk. So the project has been around since 2008, and since that time, we've helped a lot of European SMEs to protect their intellectual property when doing business in China. We cover the 4 jurisdictions in China. So we cover mainland China, Hong Kong, Macau, and Taiwan. So if you're a European small or medium enterprise, you're welcome to use our services. They're all free of charge. And we are there to help you make sure that your business is successful in an IP conscious way when you decide to internationalize to China. Our main service is a helpline. So if you have any questions that you don't want to be searching for hours on the internet for, you can always drop us a line in our email, or we also have the phone number here on the screen. And we always get back to you in 3 working days with very concise but detailed answers. So if you are not sure what the process is like to register your copyright in Macau, and that's just something that you keep looking for and you can't find it, and it's very specific, you can always drop us the question on our helpline and we'll get back to you very quickly. And it's all also confidential. So you're welcome to ask us the questions and none of your data will be shared or anything. Our other services include trainings. So we have trainings and webinars like this one all the time. And anybody is welcome to join, of course. We're mostly focused on European SMEs. But if, for example, you want to start an SME and you think that you would like to do business in China, you're obviously also welcome to join. And all of our webinars are either focused on a sector or focused on a specific part of doing business, for example, this one. And they're all there to help European companies. We also offer one-on-one consulting sessions with our IP business advisor. So you can book these sessions, you can take advantage of however many sessions you need, and you tell our business advisor about your business and what your goals are in China, and she can help you come up with a very good business plan that will help make sure that your IP is protected. And she can also review any questions that you have and make sure that you're very well aware of what to expect when doing business in China. On our website, we also have a lot of self-learning materials. We have a lot of IP guides. We have a lot of industry-specific guides. And they all cover different things that you should know during this process. And on our website, we also have other resources that will help make sure that you're prepared for China. Like we have a diagnostics tool, so you can fill out a questionnaire and it'll tell you exactly where you are in that process and what other steps you could be doing. So really, we offer a bunch of services that make sure that you are prepared to make sure that your intellectual property is protected when you internationalize your business to China. These are a couple examples of some of our guides. We have some that are region specific. So here, for example, we have one on mainland China, and it covers all the basics in a very detailed way of what you need to know and what to expect. And we also have some that are industry specific, but also some, for example, here about making sure that you know your local partners, your local business partners in China. The second guide on the screen will walk you through what to do to make sure that you know who you're doing business with and making sure that you protect your intellectual property. The China IP SME Helpdesk is part of a larger family of help desks. And so if you are thinking of internationalizing your business to other parts of the world, we also have help desks for these other regions. So you're welcome to go to our website, and it'll also lead you to the websites of these other projects. And you're also welcome to join us on our socials. So we have X, we have LinkedIn, and on those we always share bite-sized pieces of our services and little information to make sure that you're always up to date on what's happening in terms of intellectual property in China and making sure that you know everything that you have to know before doing business there or while you're doing business there. We also work with a lot of companies that are already present there and need help. And also, if you have to leave halfway through this webinar or if you couldn't make it, you can always go to our YouTube and we upload all of our webinars there. And we have a lot of videos on there too. So we have a QR code here if you want to see more about that. But yeah, so you're welcome to follow us on the socials. And for me, that's it. I'll now give the floor to Gwen, who's the Executive Director of the Flanders-China Chamber of Commerce.
Thank you very much, Mariana. So ladies and gentlemen, good morning. So also on behalf of the Flanders-China Chamber of Commerce and the EU-China Business Association, I would like to warmly welcome you to our 12th joint webinar with the China IP SME Helpdesk. It is very important that companies doing business with China also have an IP strategy included in their China business plan. Doing business has become more complex. One of the reasons is China's slowing down of the economy, which is compared to other large economies, still one of the fastest growing economies with a growth of 4.7% in the second quarter. Next to that, the global economic slowdown, the geopolitical tensions make it more difficult for European and Chinese companies to navigate in this challenging business environment. This confluence of developments demands that European companies in China need a new China playbook for Europe operating in China. But despite the fact that doing business with China has become more complex, many of our companies view it as imperative to maintain a footprint in China, not only because of its market size, supply chain, dynamism, and industrial clusters, but more and more for its innovation power. The speed of innovation in China is very fast and keeps our companies sharp. For some companies, China is a place to sharpen their competitive edge. If they can make it there, they can make it anywhere. And as some of our members also say, doing business with China can be a risk, but not doing business can be a bigger risk. If our companies want to keep up with the technology of the future, then they must continue to invest in China. The World Intellectual Property Organization just released the Global Innovation Index 2023 and ranked China as 12th, up from the ranking of 14 in 2022 on the Global Innovation Index. Switzerland ranks first. The Global Innovation Index also showed that 3 Chinese science and technology clusters, first Shenzhen, Hong Kong, Guangzhou, second Beijing, and third Shanghai, Suzhou, were among the world's top 5. So being in China shouldn't be really a choice. You must take advantage of the innovation and the local market. But let me now say a few words about the role of the Flanders-China Chamber of Commerce. So our chamber is founded by the largest investors from Belgium and China, such as Ageas, Agfa, Bekaert, Barco, Picanol, Umicore, and so on. Our aim is to assist Belgian companies to enter the Chinese market and Chinese companies to invest in Flanders. Our companies are executed also with the support of our structural partners, Flanders Investment and Trade, and our aim is to provide information, exchange of experiences, and share our network in China and in the EU. We provide a weekly newsletter to keep you up to date on China's economy and foreign trade. We organize webinars such as today with the IPR Helpdesk. We are also on many other topics such as on AR, taxation, any topic that you need to know when you want to do business with China. We also give expert advice and receive Chinese delegations and introduce them to our member companies. We are also in charge of the EU-China Business Association, which is the association of bilateral China business associations promoting the economic and trade relations between China and the EU. The EU-CBA is the association, as I said, which counts 20 member associations and represents more than 20,000 European and Chinese companies. We are also an official associated partner of the EU SME Center. The EU SME Center is a European Union initiative that provides a comprehensive range of hands-on support services to European SMEs, getting them ready to do business in China. Their team of experts provides advice and support in 4 areas: business development, law, standards and conformity, and human resources, from first-line advice to in-depth technical and solutions. They offer services through knowledge, advice, training, advocacy, and we also keep you informed about those activities and the activities about our chamber. I would like to end here and give the floor back to Mr. Valentin Delecour, who is also a member of the Flanders-China Chamber of Commerce and IP expert of the China IP SME Helpdesk, and who will deliver a training on key IP considerations to collaborate with Chinese partners. Thank you.
Thank you very much, Gwen. I will first share my screen. Can you see my screen?
Yes, we do.
Okay, perfect. Well, hello everyone. Very happy to be here. Thank you, Gwen, for this interesting and to the point introduction. Today we're going to be speaking about IP, about key IP considerations for collaborating with Chinese partners. Few words on myself. As Gwen has mentioned, well, I'm a Belgian qualified IP lawyer. I've been active in the IP field for the last 20 years. I mainly focus my practice on both contentious and non-contentious IP matters, with a strong focus on patent law and trade secrets. I work a lot with China because I used to live and work there. I spent 4 years in Shanghai, mainly working for a Chinese IP boutique. I was 100% focused on supporting European business with their IP issues when dealing with China. And well, since then, I never stopped being active in the IP and China field. Today, I mainly focus my Chinese practice on transactional work, a lot in the medtech and biotech work when it comes to China. But I have experience, a broad experience in litigation, building IP portfolios, etc., etc. I'm working with the China SME Helpdesk for the last 12 years now. And well, Osborne Clark Belgium, as Gwen mentioned, is a member of the Flanders-China Chamber of Commerce. So the topic of today is a quite broad topic. I have to say that I have decided to approach this topic on a very high level, high level. So I won't dig into really the details of Chinese IP law. The idea here is to give you some awareness about things you need to pay attention when you are meeting with Chinese partner, when you are preparing for exhibiting your company, your business, your products, your technologies on trade fairs in China. So it's fairly high level. If we have really IP focused people in the room, the webinar is maybe not addressed to you. It's more really addressed to business people to give you some basic takeaways that you should take into account when you deal with China and when it comes to IP. So first thing I would like to stress and come back on the importance of intangibles in today's economy. This is a very interesting graph because it shows that in 1975, well, intangible assets of S&P 500 companies constituted 17% of the corporate value. If you fast forward 45 years later, 2020, intangible assets account for 90% of the corporate value of these companies. So, well, bottom line, intangible assets is really what gives value to a company. The capacity to innovate and the capacity to appropriate, to control, to monetize the result of your innovation is really what gives value to a company. And how do you protect the result of your innovation? Well, with intellectual property. basically with IP rights and with trade secrets. I will come back on the distinction, the difference between these two notions. Now, IP is extensively used by the largest companies in the world. Here is an extract of an article published on the website of the WIPO, the World Intellectual Property Organization. What does it say? Well, intellectual capital is the foundation for the market dominance and continuing profitability of leading corporations. Basically, IP and the intellectual capital is the most important asset of the world's largest and most powerful companies. Bottom line here is big companies, big corporates will obviously massively invest in innovation and in the protection of the result of their innovation. And so big corporates massively invest in developing sound intellectual property strategies. Now, the question is, of course, well, as an SME, should I invest in IP? And why should a European SME that aims at doing business in China, why should it care about IP and why should it invest to protect its intangible assets? Because it's definitely an investment. Developing a sound IP strategy will require you to dedicate financial means, human means, time, money, but is it worth it? Obviously, I have listed here a few reasons why it is relevant to invest in IP strategies, and certainly when you consider doing business in China or with China. First reason, well, it's protect your competitive advantage. The whole idea of IP is to give you an exclusive right. So an exclusive right is basically the right to exclude others from exploiting the object of your rights. You have a patent, well, you can exclude others from exploiting your invention, which is patented. And so the idea of an intellectual property right is to grant you a monopoly. And so, well, you innovate, you have a competitive edge, you seek to obtain a monopoly on rights that enable you to be the only one that has the possibility to exploit this. If someone else does, well, you can go to the judge and you can obtain an injunction, damages, etc., etc. That's the whole idea of intellectual property rights. Second reason, and I think it's especially relevant when it comes to China, is to attract investments. If you seek financing, if you seek to seek money in China, for example, which I still see clients doing nowadays, well, it will be an absolute must to have a sound IP strategy that has been developed to protect your competitive advantage. And it's one of the first things that a Chinese investor will do, or Chinese partner, is to check whether or not you have a relevant IP portfolio. So very important to take that into account, to have sound IP strategies with a relevant territorial coverage that covers and that focuses on China. The third reason, which is really important, and again, really important when it comes to China, is an FTO. What is an FTO? Well, it's a freedom to operate. Basically, developing a sound IP strategy will enable you to reduce the risks which are linked to technology commercialization. You put a technology on the market, new products, well, there's always a risk that your new product, your new technology will infringe the rights of third parties. And as you may know, and I will come back to this, China is a country where you have massive amounts of IP rights that are enforced. Every year, you have massive amounts of IP rights that are applied for and that eventually get registered. And so the risk is very real that when you access the Chinese market, well, you may have a Chinese competitor or a foreign competitor which has developed an IP portfolio covering China that will attack you because it considers that you are infringing IP rights of others. And there's a clear trend nowadays in China when it comes to IP litigation. More and more foreign companies are being attacked for IP infringements by their Chinese counterparts. And so again, developing a good IP strategy can help you limit the risks of infringing the rights of third parties when you access the Chinese markets. Another reason why you should have a strong IP strategy when it comes to China is to increase control and decrease the risks that are related when you outsource. China remains a very important place when it comes to manufacturing, sourcing, and basically parts of complex supply chains. Very often, complex technological components will be manufactured in China, and having a good IP strategy may help you, again, limit the risks of, well, basically sharing your technology with a potential Chinese manufacturer, because you will have good contracts to help you secure your rights. But if you have, for example, a good patent portfolio that covers China, that covers the technological components that you aim at being manufactured in China, well, you will be able to attack, for example, the Chinese manufacturer if he infringes and steals the IP that covers the tech component that you are manufacturing in China. So very important also when you outsource manufacturing to have a strong patent portfolio and IP strategy in place. You have also tax purposes. You may be aware that in Belgium we have a very attractive tax regime for revenues which are generated by IP, by patents, and sometimes softwares that have been developed in Belgium. And then last but not least, and really relevant for the topic of today, IP can be absolutely key when you enter new markets, because it will make you more attractive. And very often what I see in my practice, well, impossible to develop a strategic partnership with a Chinese partner if you don't have a good China IP portfolio in place. Because a Chinese partner will not invest in the relationship, will not invest in the development of your business in China if you don't have an exclusivity, if you don't have exclusive rights, if you don't have relevant IP portfolios in place. Typical example, a China joint venture. You bring technology, your partner brings you market access knowledge. He will pay attention to the fact that your technology is protected in China. So bottom line, IP is at the heart of any internationalization strategy, and it's absolutely key to succeed on the Chinese markets. Now, few slides again on the importance of IP for China's economy. Very briefly, I think it's important to remind how much IP has evolved in China over the last decades. And it's really impressive to see what the country has achieved in implements an efficient and modern IP system in less than 4 decades. At the end of the 70s, the country decides to open up to the outside world under the impulse of Deng Xiaoping. And at that time, well, it was really an IP no man's land. You had no patents, no trademarks, no judges, no lawyers, nothing. Today, 2024, well, IP has become a top national priority. Why? Well, because as you all know, China is very much investing in innovation. And when you talk about innovation, well, IP is never really far, because it's really a tool to enable businesses to protect the result of their innovation. And so the country has been massively investing in developing a modern IP system, and they have succeeded. So, well, today you have a complete set of Chinese IP laws in place. What is interesting is that you have a very high legislative dynamism. The Chinese legislator is constantly working on improving the IP laws. So you have loads of reforms, of changes in the IP laws, really to adapt them and make them more relevant to the Chinese economies, Chinese businesses, and foreign businesses that are active in China. And very important is that IP is a central part of China's development strategy. They have the ambition to become an IP right powerhouse by 2035, sorry, there's a mistake there. They have a 15-year plan to develop the IP system by the end of 2035. It was announced in parallel of the 14th five-year plan. And so it's again a confirmation on how important IP is for the country and how much they are working to have a top-notch IP system in place. Second, well, important to realize that China is the #1 country in the world when it comes to the number of patent applications. 2015, first time that more than 1 million invention patents were filed in China. It made the headlines because it was the first time in history that so much inventions patents were filed with a single patent office. So, okay, it's big numbers, and this trend has continued. If you look at the numbers in 2021, more than 1.5 million patent applications had been filed. What is interesting is two things. First, mainly domestic filings. So these massive amounts of patent applications originate from Chinese companies or from companies that are based in China. And second, this is more relevant and more interesting, is the shift from quantity to quality. So in the 2010s, you had loads of subsidies that had been put in place really to push Chinese companies to file patents. And you had this phenomenon of junk patents that actually had no value. This is changing and has been changing. The country is now investing in quality IP. So they have reduced patent subsidies, and companies now are really more applying for patents applications that are relevant and that have value. Third, not only are Chinese companies massively filing at home, they also internationalize. You probably all know that, and so does also their IP portfolios. And so if you look at PCT applications, and PCT is basically, to put it simply, an international way of filing patents. Through one single application, you can designate plenty of countries where you want to obtain patent protection. Well, China was the #1 PCT applicant in 2021, with Huawei, the Chinese telecom giant, as the top PCT applicant. And what is interesting is when you look at the statistics released by the WIPO, the World Intellectual Property Organization, well, you realize that China is #1 when it comes to university PCT applicants, government PCT applicants, and businesses. So across all levels of the Chinese economy and the Chinese structure, university, government, businesses, they all massively invest in developing patent portfolios abroad. Well, Gwen has insisted on this, and I think it's very important to be aware of this. R&D spending in China has massively grown over the last years and decades. China is now an innovation powerhouse. And I was researching for doing this seminar and came across this article that says that, okay, nowadays with the Chinese economy slowing down, the US still has an edge when it comes to global R&D spending. But one thing that we should be aware is that the EU lags both significantly. The EU lags behind the US, the EU lags behind China. And I think it's unfortunate, and it's a pretty negative information for the future, because it's only by continuing to invest in innovation that Europe has a chance to stand and remain competitive towards, among others, Chinese companies. Very important in China is obviously politics, and important to realize that IP has become and has been for many years now a political imperative. China has a clear strategy to achieve technological sovereignty and industrial upgrading. And well, currently, as we're speaking, you have the third plenum of the Central Committee of the Chinese Communist Party, which is taking place. One of the big issue and topic is innovation, and is putting in place the relevant regulations, laws, and defining the relevant strategy to achieve the strategic goal of the country to be technologically self-sufficient. So the country wants to end their reliance on foreign tech. They're working very hard on this for many, many years now. I think this opens up plenty of opportunities nowadays for some European companies that are active in the relevant sectors. But it's clear that in the longer run, well, it's going to be more and more difficult to be relevant on the Chinese markets. But what is certain is that focusing on this technological self-sufficiently means that the country is focusing on innovation, and so that leads to a focus on IP, as you have understood. So IP is clearly a driver of innovation, but China has also this edge that they have a very strong central government. the Communist Party that is basically planning, and they have very strong centralized planning that they are exploiting to their benefit when it comes to innovation, to R&D. And again, that also is a very strong driver for the innovation. So, well, what is the key learning of all these facts and numbers and trends? It's basically that intellectual property is now absolutely essential for Chinese businesses. And Chinese businesses, they are IP aware, they are IP rich. They have perfectly understood that IP means protecting your competitive advantage, that IP is there to enable you create value, to enable you to grow. And so they are exploiting this. And this means that China's stake in the IP system has grown, is now significant, and that Chinese businesses, well, are basically strong IP competitors. And so you need to take that into account when you go to China and when you enter into discussions, negotiations, relations, partnerships with Chinese partners. So, well, how to protect your IP when meeting potential new partners or doing trade fairs? And here I would like to go through a few slides, a few tips. Again, it's very high level, but it's very important, especially for non-legal and non-IP people, to be aware of this. The first thing, and may sound common sense, but it's very important, it's that you need to plan ahead. If you want to protect your IP, well, you need to be proactive. And it requires to be prepared before going to China, before meeting partners, and certainly before exhibiting your products, your technologies, your services at trade fairs. So what does that mean? Plan ahead. A few tips. The first thing is that you should know what you have to protect. And when I see that in my practice very often, smaller companies, startups, scale-ups, SMEs, well, they don't have a good overview of their IP assets. And if you want to protect something, well, obviously, it's important to know what it is that you have to protect. And so it's very important to conduct an IP audit, to map your IP assets, to understand what it is you have that should be protected. So important to have a comprehensive overview of your IP assets for your products, your technology, to ascertain whether or not it is protected, to ascertain the legal status, the territorial coverage, the value, the related risks to your IP. And so there are a few basic questions that you need to ask yourself when you do an IP audit is, well, are my products and are my technologies protected? If I want to be active with China, well, are these rights and these products and technologies extended to and protected in China? How are they protected? Am I using IP rights? Am I using trade secrets? Am I using any kind of protection at all? And basically, is the protection that I have or that I think I have relevant business-wise? So that's really the first thing you need to do and to ask yourself is what it is that I have that I need to protect. And you really need to understand what to protect. It's common sense, but it's extremely important, and it's actually not that easy because, well, basically intangible assets are non-physical, are sometimes difficult to identify. And I'm always amazed especially when you negotiate, for example, collaboration, R&D agreements between companies, that very often companies do not have a precise view of what it is that they have, that they can leverage, that they can bring to a co-development project. So understand what it is you have that you need to protect. Step 2, once you have done that, very important to understand how to protect that and how to protect your competitive advantage. And I already alluded to it, but important to understand that you basically have 2 ways to protect the results of your innovation. You have intellectual property rights and you have trade secrets. And these are 2 different things, 2 types of rights that obey to a different logic. An IP right, as I mentioned already, is an exclusive right. So you have a monopoly. You can exclude others from exploiting, using, implementing the object of your rights. And what is very important to understand is that you have different types of IP rights and different types of IP rights because they serve different roles and they serve different goals. So a trademark, you will use that to protect distinctive signs, to protect the indication of origin of your goods or services. You're investing in developing a trademark portfolio to protect your identity and to enable customers to differentiate your products, your services from those of others. Patents, they serve a totally different goal. They are there to protect technical and technological features of your products, of your processes. Designs, they're there to protect the external aspect of your product or part of your products. And then you have copyrights. They protect creative works. It's a very broad notion, it goes from text to music, but also to software. So a very important right as well, and with specificities when it comes to China. So important to understand that you have different IP rights that are there and that you should exploit. And very often, when I'm confronted to smaller, younger companies, well, they focus very much on one type of rights, one patents. They focus on their trademarks, on their patents, maybe on their designs, but they do not take advantage of different types of IP rights that are there. And basically, as a rule, and I think it's very much true when it comes to China, the more IP rights that you have, the better equipped you will be to face sometimes, well, challenging and difficult situations on the Chinese markets. So the idea really is to create a bundle of rights. All these rights are complementary, and you should use them all. Obviously, put in place a strategy that makes sense business-wise and budget-wise, but very important to be aware of that and make the relevant choices. So that's for intellectual property. Trade secrets, it's different, it works differently. It's a protection that is based on the nature of the information. It must be commercial information that has value. And it's also a protection which will be based on the way the information is handled by the holder. As a trade secret holder, you have to proactively put in place a set of measures to protect the confidentiality of the information. I will come back to this, but it's a requirement to be protected. And the big difference between trade secrets is IP is that IP grants you an exclusive right. A trade secret does not grant you an exclusive right. A trade secret will protect you against certain unlawful acts. The unlawful access to your trade secrets, use of your trade secrets, disclosure of your trade secret to third parties. If you can prove that there is an unlawful access, use, or disclosure, well, then you can rely on the trade secret protection regime and obtain injunctions, damages, etc., etc. But so it's a different logic, exclusivity and protection against unlawful acts. Step 3, you know what to protect, you understand how you should protect it, and step 3 will be to develop your IP portfolio and to make sure that you have enforceable IP rights in China. And this is a very basic but very important slide. Always keep in mind that IP rights are territorial rights. They are related to a specific territory, to a specific jurisdiction. And so it doesn't mean if you have a patent applied for the European Patent Office and a patent granted in Belgium, well, obviously you won't be protected in China. So you need really, when you develop your IP portfolio, to make sure that you cover the relevant countries and jurisdictions, which are the countries where you trade, countries where you manufacture, countries where you exhibit, you participate to trade fair, relevant to have an IP portfolio that covers these jurisdictions. Can make sense also to cover countries where your competitors are located and possible investors, and that is certainly true for China, as I mentioned already. And same thing when it comes to possible partners, make sure that you have IP rights in place, because it will make you more attractive and it will make you relevant for Chinese partners to invest in the relationship. So keep in mind territoriality of IP rights. Second thing, which is very important, is that IP protection is not automatic, with the exception of copyrights. So what does that mean? It means that you have to register your IP rights. You need to apply for protection. You need to go through a registration process which can be painful and costly sometimes, and China is not always easy, but that requires you to anticipate, that requires you to plan ahead, because sometimes it's too late and you cannot obtain any more patent protection, IP right protection. Typical example, a patent, you apply for protection in Europe, you obtain a granted patent in Belgium. 5 years later, you decide to go to China. You did not apply for patent protection in China. It is too late because, well, your invention will have been disclosed. And once it's disclosed, it's not novel anymore, which means that you cannot obtain patent protection. So very important to anticipate and to plan early. And keep in mind that not applying for patent protection in China, well, that means granting a free license to use your invention to your Chinese competitors, to your foreign competitors that are active in China. If you don't apply for protection, and if you disclose your invention, well, then it's in the public domain and anyone can exploit it in China. But not only in China, it's a basic principle of patent protection and of IP right protection. Any country where you don't have a patent granted or applied for, well, basically, the invention can be freely exploited. So very important to take China into account in your IP portfolio building. And last but not least, important to adapt to the specificities of the Chinese IP system. The main principles are basically the same all over the world when it comes to IP, but obviously in practice, you have very important and very significant differences. And so it's important to work with people who really understand and have an experience of the Chinese IP system. Step 4, extremely important, is to use contracts to protect your IP. Contracts are absolutely key when you do business in China. It's very important to negotiate your contracts in great detail and to pay specific attention to IP and to confidentiality clauses. So not much to say here, except that IP is relevant to numerous contracts. Obviously, technology contracts, co-development, tech transfer, patent licensing, technical consultancy and services agreements, they're all focused on innovation and on IP. Same for trademark and copyright licensing. But don't forget that when you manufacture, extremely important to negotiate in great detail your IP and confidentiality provisions when you outsource. Same when you distribute, when you identify distributors, you will share loads of confidential information with them, possibly, well, important to have good confidentiality clauses in place. Same for your employment or your consultancy agreements. Extremely important to have relevant IP and confidentiality clauses that are drafted and adapted to the Chinese system and that you can enforce in China. So lesson number 4, have enforceable contracts. Typically, when it comes to confidential information, make sure that you execute an enforceable NDA before disclosing anything of value to a possible Chinese partner. So recap, actions to take to protect your IP before meeting a possible partner or attending a trade fair. Know your IP, perform an IP audit, know what to protect and understand how you can and should protect it. Create a bundle of rights. Keep in mind that you have different types of IP rights. They all serve different goals. They're complementary, and you should take advantage of these different types of rights. Make sure that you have enforceable IP rights. Keep in mind that IP rights are territorial. Protection is not automatic, so be proactive to build a relevant IP portfolio that covers and targets China. And last but not least, use enforceable contracts. Second, I would like to dive a bit on patents and trade secrets in China. I see that I'm a little bit running out of time, so I will accelerate a bit. Well, just one slide for Chinese patents in a nutshell. Important to know that in China you have 2 types of patents. You have invention patents, and these are basically similar to the patents that we have in Belgium and in Europe. Invention patents can cover a product, process, combination of both. while utility models, which are kind of smaller patents, well, they can only cover products. 3 conditions for patent protection: novelty, inventiveness, practical use. Basically roughly the same as in Belgium. You have also differences between invention patents and utility models. Just keep in mind that for utility models, the level of inventiveness is lower. And so it's basically easier to obtain protection by utility models for certain product-related inventions, because the inventiveness requirement is lower. So important to be aware of that and to exploit that. And then in terms of duration of protection, well, an invention patent is 20 years as from the filing date, while a utility model is only 10 years as from the filing dates. But both will grant you an exclusive right, so right to exclude others from manufacturing, using, offering to sell, selling the patented products, from using the patent process and also product by processes without your authorization. So it's what I explained: the exclusive right, the monopoly on the objects of your patent, on your inventions. Second, trade secrets in a nutshell. Basically, well, trade secrets, so your commercially sensitive information. Trade secrets are very often the crown jewels of many companies. It's very often what a Chinese partner may be looking for. And so it's important to understand what can be protected as a trade secret. And the beauty of trade secret is that it can cover a very wide range of technical, commercial, operational information. It can cover processes, methods, algorithms, data sets, computer programs, strategies, clients lists, information on your supply chain. All that can be protected as a trade secret. Basically, any type of information can be protected as a trade secret if it meets the protection requirements. What are these? Well, the information must be secret. It must not be known to the public. It must have commercial value because it is secret, and you must be able to prove that you have adopted reasonable steps to keep the information secret. So you need to undertake reasonable efforts to maintain secrecy. These are the conditions in China. They're exactly this, roughly very similar in Europe, in the US. The same requirements are there: secrecy, commercial value, reasonable steps to protect the secrecy. And if you're able to meet that in information, any kind of information, technical but also non-technical, meets these requirements, well, then you can benefit from the trade secret protection regime. Important to know that in 2017 and 2019, China has revised its anti-unfair competition law, which is the main body of law to protect trade secrets, to strengthen the Chinese trade secret protection regime. And so, well, since these revisions, you have more information that may qualify as a trade secret in China. You have more acts that can qualify as misappropriation, and so against which you can act. You have more people that may be held liable of trade secrets, misappropriation, misuse, and they also have put in place a reverse burden of proof. The main challenge when it comes to trade secrets is evidence. It's proving that there has been an unlawful act. And nowadays, with since these revisions of the Chinese anti-unfair competition law, well, if you can prove that you have basic evidence of the fact that you have taken confidentiality measures and that the trade secret has been misused, misappropriated, well, then the person that you accuse of trade secret misuse and misappropriation will need to demonstrate that he did not. So you have a reversed burden of proof, which is extremely useful when you have to litigate trade secrets. So, as I mentioned, very important when it comes to trade secrets to adopt a set of confidentiality measures. You need to be able to prove that you adopted reasonable steps to keep the information secrets. And so it's all well and good to have an NDA signed. That's really the basic think that you should do, but you need to go further than that. You need to adopt a whole set of measures to protect the secrecy. If you do not do that, you won't be protected. And basically your information will be considered as being part of the public domain, which means that anyone may freely and legally exploit it. So very important to adopt a variety of measures, legal, HR, IT, organizational measures to protect your confidential information. And what is interesting in China is that you have an interpretation, traditional interpretation that has been issued by the Supreme People's Court, the highest Chinese jurisdiction, where they give a non-exhaustive list of confidentiality measures. And so it's a very useful guidance. I've reproduced them here. You will have access to the slides, so take a look at it. But basically, what does the Supreme People's Court say? Well, use contracts, train your people. They should be aware what information is secret and what they can and cannot do with it. Put in place physical barriers to control the access to your trade secrets. So access management is very important. Put in place relevant IT measures to protect your system and the confidentiality of your information. Pay attention to your employees, because most of the trade secret issues will be related to employees or ex-employees. So HR management is extremely important when it comes to trade secret protection. And then they have this catch-all provision. Any other reasonable measures of confidentiality can be adopted. So it's an open notion. But basically, the bottom line is you need to implement several measures in place to protect your information as trade secrets. So recap, trade secret protection requires proactivity, audit and improve your protection measures. Having an NDA is a good start, but it's not enough. Very important to document all transfers and your confidentiality measures. But so if you sign an NDA, keep this in mind. You need to document every information that you share, because you will need to be able to prove that specific information falls under the scope of your NDA. Pay attention to your employees, your consultants, your business partners. They are the main threats to your trade secrets. And basically, enforcement is challenging, so you need to document everything you have to be able to prove a trade secret misappropriation. And so yeah, it's a little work to put in place a trade secret protection strategy, but keep in mind that if you do it, basically the measures that you put in place will be useful in China, but also for EU and also for the US. So it is very often worth investing in that. So why patents? Why trade secrets? At some point, you will have to ask yourself, do I want to go for patent protection? Do I want to go for the secrecy? There's a whole set of questions and criteria that can be taken into account to take the relevant decision. And then last but not least, don't forget your other IP rights and especially your trademarks. Very important when you do business and before meeting business partners to have your trademark registered. In China, you have many filings that are done in bad faith. So third parties that register your trademarks and then that invoke them against you or try to sell them to you for a lot of money. Chinese trademark laws have been adopted to fight this bad faith filings, but still prevention is better than cure. So file sooner rather than later. Really important to have your trademark registered before doing business with China. So, well, it's 11, so I will go to my last slides. To conclude, what are the key IP considerations you should take into account while collaborating, negotiating, meeting with Chinese partner? Well, first, be proactive and have a tailor-made China IP strategy. Very important to start early. You need to plan ahead and anticipate and define your strategy. Second, know your IP. So perform an audit, as I explained, very important to understand and to identify what it is you need to protect, to prioritize and to work with relevant people to be protected. Build a good IP portfolio, pay attention to your trade secrets, negotiate your contracts in great detail, and don't forget your trademarks. Second, sign NDAs to protect your trade secret and confidential information, but remember that it's not enough. You have a whole set of confidentiality measures that you should put in place. Third, organize what you share, make a good selection and evidence what is shared. And last but not least, select your leads, perform background checks, vet your partners. This is also a common sense, but very important measures to do. You need to work with the relevant people. So that's it. Thank you very much for your attention. Not sure we'll have time for a Q&A. Apologies for that, but feel free to send me an email. If you have any question, I'll be happy to answer them.
Great, Valentin. Thank you so much. And so yeah, as he said, if you have any questions, you're welcome to email him directly, but also you can send us an email with the address I sent earlier. That's question at China-IPR helpdesk.eu. I'm not sure about that, but I'll get back to you on that. So yeah, if you have any questions, reach out to me or to Valentin, and if you reach out to me, I'll forward him the question. And that's it. Thank you all so much. Thank you, Valentin, for the very informative session. Thank you, Gwen,
My
for
pleasure.
co-hosting. And thank you, everyone, for participating.
Okay, thank you very much, Valentin, Mariana. Thank you. Very interesting, Valentin, as usual. Thank you. And practical.
Thank you. Bye-bye.
Thank you.
Bye, everyone.
Bye.
Have a great day.
Bye.